If you want clear and honest updates on Italian citizenship, subscribe now and hit the notification bell. The next few months will be decisive. Let me start with something that should get your attention. In Italy today, a minor can lose citizenship retroactively, without any notice, without any hearing, and without any way to defend themselves. And for the very first time, a court has said this may be unconstitutional. Stay with me because what you are about to hear has huge consequences for thousands of families. Before we look at the decision of the Court of Mantua, we need to take a step back. This is not an ordinary case, it's not a typical citizenship petition. It's a special judicial procedure filed under the Article 95 of a presidential decree of the 2000. What does Article 95 mean in practice? It's the legal tool you use when a civil registrar unlawfully refuses to perform an act they are required to perform. It's a direct action against the denial issued by a public authority. And this is where the core of the case begins, because the registrar's refusal was not just a mistake. It revealed a much bigger problem. In the Mantua case, the parent had already obtained a court judgment recognizing their Italian citizenship iure sanguinis. A clear judgment. Immediately effective. After the judgment, the parent asked the municipality to register their minor child as Italian. A normal request. One that, before to 2025, was handled automatically. But this time, the registrar said no. They refused to register the child. And they justified the refusal by citing the 2025 reform introduced by the Law 74 of 2025. According to registrar, the child had never acquired Italian citizenship, and therefore there was nothing to record. This point is crucial. The registrar applied the reform as if it could reach backwards into the past, as if it could erase a status that already existed. The judge, however, reconstructed the case in a completely different way. They started from a simple legal principle. A minor born to an Italian citizen is Italian from birth. This was true before the reform, and it remains true after the reform. The legislature can change the rules for the future, but it cannot retroactively raise an existing citizenship. It cannot eliminate a fundamental personal status, and it cannot do so without a proceeding, without a hearing, and without a judge. And here comes one of the most important passages in the entire decision. The judge says clearly that calling this a failure to acquire citizenship does not change anything. If you were Italian and now you are not, that's a loss. And if that loss is retroactive, it's highly questionable under the Constitution. This is exactly where the referral to the Constitutional Court comes from. The judge states that applying the 2025 reform retroactively produces a revocation ex tunc of the child's citizenship, a revocation without fault, without procedural guarantees, and without any opportunity to defend oneself. These, according to the judge, may violate several constitutional principles: personal identity, equality, protection of minors, right to defense, legal certainty, the principle of proportionality, the separation of powers, limits on emergency decrees, and even the logic of Italy's citizenship system itself. For this reason, the Court of Mantua cannot decide the case alone. It refers the matters to the Constitutional Court, because the reform as applied may not pass constitutional review. Let me now give you a clear breakdown of the key points in the reasoning. Point 1. The minor is the child of a parent recognized as an Italian citizen by a court judgment. The parent's citizenship status retroacts to their birth. Therefore, at the time of their child's birth, the child had an Italian parent. Point 2. In Italy, the citizenship of minors is automatic. It does not require declarations. It does not require applications. It's a legal status, not a discretionary benefit. Point 3. The municipality applied the reform as if it raised rights that already existed. The judge says this interpretation is wrong because it breaks the internal logic of Italy's civil registry system. Point 4. The reform creates an obvious contradiction. The state recognizes that the parent is Italian, but at the same time denies that the child is Italian. A legal paradox that cannot stand. Point 5. The court makes something very clear. Calling this failure to acquire citizenship changes nothing. If citizenship existed and now no longer exists, that is a loss. And retroactive loss is, by definition, constitutionally suspicious. Point 6. According to the judge, the reform may violate a long list of constitutional rights: identity, protection of minors, equal treatment, legal certainty, procedural rights, and the constitutional limits on retroactive legislation. Point 7. Given the scale of these concerns, the court raises the issue before the Constitutional Court. And this is why the Mantua case is considered one of the strongest constitutional challenges to the 2025 reform. Now, you understand why this case is so important. If the Constitutional Court rules that the retroactivity is unconstitutional, everything changes for the Italian descendants worldwide. If you found this video helpful, please subscribe to the channel and leave a comment. It really helps me keep producing clear and independent content. And if you want to discuss your personal case or explore your options, you can book a personalized consultation through the link in the description. I want to close with an important question. Do you want more videos like this, where we break down court decisions and legal rulings in detail? Do you enjoy this format? Let me know in the comments, because if you do, I can bring you more of these every week. See you soon.